Hello and welcome to today's employment law update presented by Ciphr with our friends at Shoosmiths. It's great to have you with us today. I'm Catherine, I'm Ciphr's head of content. Joining me today is my colleague James, who's one of our sales managers. And from Shoosmiths, we have Stuart, Sean and Antonia, who'll be here to take you through all the latest legal updates, case law and a look at SOSR, or SOSR dismissal. Not hanging around this morning because we've got lots to get through, so we'll pass back to Stuart, Antonia and Sean later on, but now I'm going to hand over to James and he's going to give you a 5-minute introduction to who Ciphr is and what we do before we get stuck into our employment law update.
Thanks, Catherine. So hi everyone, as Catherine mentioned, I'm one of the sales managers at Ciphr and I've got the privilege to talk to you about Ciphr for a couple of minutes. For those of you that are unaware of who we are and what we do. So Ciphr's been around for about 40 years now and we specialise in people management solutions. And that's really about aligning our solutions with your employee journeys to kind of get to that dream state of a single source of truth for your people data, but also that single point of data entry, which I'll touch on in a few moments. We can very much support the start of that journey with recruitment. So that's not just about giving you the tools to publish job adverts and manage your applications, but also give you the ability to promote your own brand through tailored careers pages. We're then into the realms of onboarding, and that's really about engaging with new starters before they even walk through the front doors on their first day through a range of content, including videos. And that could be talking about your culture, introducing them to colleagues, but also taking the anxiety out of their first day with floor plans, pictures of the front door, where to park, and of course, getting those admin-driven tasks out of the way. We're then looking at sort of central HR, so it's much more than just storing someone's name and address. It's really about empowering your people to have ownership of their data and processes, but also giving you the ability to improve, engagement, communication, well-being, and also change the way that you progress, develop your people, and of course the benefits that come with automation, workflows, better analytics. Ciphr LMS is another great product that we offer, and our off-the-shelf content. So that's the ability to create a repository for your own learning content for your employees to self-discover and upskill, but also to use our off-the-shelf content to assign learning journeys. And that's a range of topics, which I'll talk about in a few moments. Of course, payroll, big part of what we do, and think about lovely clean data going from HR to payroll, be that in-house software for your payroll teams to manage that process, or the need for our bureau service to support the fully managed payroll. And then lastly, expenses, automated mileage calculations, pictures of receipts, claims on the go. These are just some of the things that we can support with to align again with your employee journey. Next slide, please, Catherine. So we took a sort of snippet of that to align with today's webinar in terms of how we can support with compliance along that journey, whether that's onboarding with pre-employment checks, background checks, the ability to integrate with partners like Experian, Trust ID, policies being read, accepted, signatures on contracts, having a dedicated part of someone's record with safeguarding to record and monitor those checks. The LMS again is a great tool to create assigned learning journeys. So you've got ready-made content you can deploy, again, for topics like compliance, diversity, inclusion, soft skills, management training, and much more. GDPR, a big one, data retention dashboards that are visually going to show you when records have hit your retention periods to delete or anonymise in bulk. And then lastly, the reference to case management, which is a really great tool to record, manage and track your HR cases within the solution. Next slide, please, Catherine. Next up is integration. So something we're really passionate about is integrations with your current business systems. We recognise you've got best of breed solutions that you're using, be that benefits platforms, be that time attendance platforms. And integration just means that you've got a single point of data entry. So HR we see sitting at the heart of your organisation. Look, you're dealing with people from that first to last touch point, and ultimately that information is being driven by Ciphr. So those integrations, two-way push and pull, will reduce admin. The big one is improved data security, integrity and accuracy, but also enabling you to use those systems effectively. And then lastly, if you've got lots of platforms that your end users have different login details for, again, they can go to one place to access everything with the ability to integrate. Next slide, please, Catherine. So just to give you an idea of some of our customers, we've got a very broad, diverse customer base. All of our customers are incredibly different, and that's down to the fact that Ciphr can be configured around your contractual complexities, your makeup of people, your brand identity, your geographics. It's about giving you a future-proof solution that can adapt and grow as you go on that journey as an organisation. Lifetime training, very different to Countrywide, very different to the ICA. Next slide, please, Catherine. Thank you. So just some passing to the words. So the right HR system streamlines your work. That is incredibly true. And of course, some of the things you would expect is better analytics reporting, board packs at the click of a button, lots of automation, workflows, notification, better communication, engagement, better integration with payroll, clean, accurate data, being able to get, new starters upskilled and more productive quicker, and of course, lots of support around compliance and automation around that. Next slide, please, Catherine. Thank you. Do you currently have challenges with your HR system? So whether you're looking for your first system or whether you've got your second, third generation system in place, if you find that you don't get people using it enough, maybe the data's unreliable, there's lots of duplication because you've got a system but you're doing lots manually, obviously we'd love to have a conversation with you to understand those challenges and to work out how we could support you with our solutions. And then last slide, please, Catherine. Just a couple of comments on why some of our customers love us, but again, we'd love to have those conversations to understand you and the challenges that you face, and again, how we can overcome them. So I'll hand you over to Stuart to take us through the first part of the employment law update. Thank you.
Thanks, James. Good morning, everyone. On behalf of Sian, Antonia and I, we're absolutely delighted to be partnering with Ciphr to deliver another employment webinar to you this morning. Thanks to Catherine and to everyone at Ciphr for the invite. For those of you who don't know me, I made our previous webinars. My name is Stuart Lawrenson. I'm a partner here at Shoosmiths, and I'm joined today by Sian Hall, a principal associate in my team, and Antonia Blackwell, who is our professional support lawyer. It's a shame that we're unable to speak to you all verbally today. Unfortunately, the systems, we've got nearly 400 people. I'm looking at the numbers. Yeah, nearly 400 people live at the moment. So we're unable to take any questions orally, but this system does allow you to ask questions through the chat function. So if you've got any questions on any of the topics that Sian and I are going to cover, please feel free to raise them, and we'll probably try and deal with them at the end. Maybe some questions that Antonia is able to respond as the session goes on. But please feel free. And if we haven't got time to cover them all, we'll see what we can do by way of follow-up. We're going to make sure we've got some time at the end. Next slide, please. So today's webinar is going to follow an ever so slightly different format to our previous webinar. We're going to do something a little bit different for you this morning. And in addition to covering off a quick update in relation to legislation and a look at what's coming down the track from a horizon gazing perspective, and me looking at I'm going to look at 4 cases all in the context of disability discrimination. We're then going to look at one of the hot topics that's landing on our desk, which is how to manage terminations where we're looking to dismiss somebody on the grounds of some other substantial reason. Ciphr and Catherine sent out the poll giving you a choice of 3, and this was by far and away the hottest topic. So hopefully we picked something that is of interest to you. Yeah, I hope you like the slight change of approach in relation to what we're covering this morning. The session's due to finish at 12:15. Anyone who knows me knows that I'm a stickler for timing, so we'll make sure that we finish on time. Next slide, please. So first off, for me, I'm going to quickly update you in relation to a number of private members' bills that have received royal assent since we last spoke. So I'm going to cover off updates in relation to carers leave, neonatal care leave and pay, enhanced protections in relation to redundancy and flexible working. I'm going to be very quick. Why? Because not much has changed, and I don't want to repeat what we have already covered in previous webinars. The previous webinars were recorded. If you didn't make those and you need a copy, I'm sure that if you ask Catherine nicely, she'd be happy to send you a copy of those recordings. I hope I haven't put too much workload to Catherine in my offering that without speaking to her about that beforehand. But yeah, so I'm going to cover, I want to make sure that we spend most of the time really focusing on the cases and Sian's section. So next slide, please, Catherine. In relation to carers leave, the position hasn't changed that much since our last webinar, other than the fact that the private members bill has received royal assent. It still looks like the case that soon employees who either provide or arrange care will have an entitlement to 1 week's unpaid leave. The one point I want to update you on is in relation to the implementation date. This is still yet to be announced. Everything is going to be specified in the regulations, and it's going to be laid in due course. That's how it tends to be referred to. But it looks like this may come onto the books in April 2024. We'll keep you updated in relation to that. Moving on to neonatal care leave and pay. Again, A summary of the detail that we provided during the previous webinar is set out on the slide, and you'll excuse me for not repeating that content again. I just wanted to update everybody in relation to the implementation date. In response to some previous written questions that were asked at Parliament, the responses confirmed that this is unlikely to be implemented before April 2025. What I would say though is that there's quite a lot of detail being published or out there already about what this type of leave is going to look like and what the rights are going to be. So if you're interested in getting ahead of the game, then do have a look to see what you can find, because some companies do like to introduce things before they're actually required to do so from a statute perspective. Turning to the enhanced protections for those returning from maternity, adoption and shared parental leave, and by way of quick reminder, everything's set out on the slide, but the extended proposed protections will extend the protected period so that it will in the future run from the point of notification and until 18 months after birth. Again, in relation to implementation, there's still a fair amount of uncertainty, but our current best guess is that this is going to be on the books come next April. The only point that I do want to repeat though is Sian and I are beginning to see an increase, unfortunately, in relation to redundancy queries. So I just want to repeat the point that I mentioned at the last webinar. So for any of you who are going through redundancy processes involving anybody who is pregnant to off on maternity leave, I would highlight again the really useful guidance that's been published by ACAS, which is a guide to managing redundancy for pregnant employees and for those on maternity leave. It really is a really good starting point reference tool, so I'd recommend referring to that as necessary. Quickly galloping through, we get on to where we are in relation to the changes to flexible working. Well, this received royal assent on the 20th of July. We still don't have an implementation date, but again, April 2024, you'll hear that date, me mentioning that a few times. That is likely to be the date that this comes in. The only point I wanted to flag here is that there's a little bit of controversy about whether or not the changes to flexible working is going to become a day one right, because there's a discrepancy between the wording of the bill and the response to the consultation. The point that I wanted to highlight is that it's fully expected that this is going to be a day one right when the changes come in. And of course, again, this is one of those pieces of legislation where some employers are, again, implementing things before they're required to do so under legislation, and the key employer that's taken the step there is in relation to Tesco's. Some of you will have seen in the press that they've introduced this already for their entirety of their 300,000 employees, and they got an awful lot of good press as a result of that. I don't know if anybody else on this call has taken that decision already, but obviously you can get a good lot of employee relations feedback if you do go over and above what you're required to. The next slide refers to a potentially really significant change to protections under the Equality Act, which relates to whether employers can be liable for third-party acts. Currently, employers can't be liable for acts of third parties, but this is one where we've had a third reading in the House of Commons and it's had its first reading at the House of Lords. What we don't have, we don't have an implementation date, but the proposal is that this is going to reintroduce potential liability for employers in relation to acts of third parties. What I wanted to highlight here is that the House of Lords is approaching this from a slightly different perspective than Parliament, and therefore there is probably a little bit more uncertainty in relation to this piece of legislation than there is in relation to others. Some of you may recall that a few years ago, employers could be liable for the acts of third parties, but that didn't stay on the statute books for too long, and that position was repealed. But there is this debate going on as to whether or not it should come back. And if it does, it will be a significant change. So if it does go through as amended, an employer will be treated as harassing an employee when a third party, such as a customer or a client, harasses an employee in the course of their employment, and the employer has failed to take all reasonable steps to prevent that harassment. And it looks like, if it is implemented as suggested, there's going to be slightly tougher rules in relation to harassment from a sexual harassment perspective than in relation to other protected characteristics. And specifically, where a tribunal finds that or upholds a claim of sexual harassment, and it finds that the employer has breached their duty and has not taken all reasonable steps to prevent third-party harassment, then the tribunal is going to have the ability to uplift compensation by as much as 25%. So similar to the compensation regime where an employer fails to comply with the ACAS code on disciplinary and grievances. Where do we think this is going to end up? I think this is going to end up in an increase in training, an increase in review of your contracts with third parties, and probably notices. You often see that, don't you, particularly in the retail sector, notices about staff being treated fairly, and I think that will change the dynamic significantly. So it's going to be really interesting to see whether or not that comes onto the books. I'm going to skip over the next slide simply because of time. Everything that we covered on the previous webinar is there just by way of summary. But I just wanted to finish this section by rattling through a couple of other things that are on the horizon. The first is there's currently a proposal to tweak the rights of fathers and partners in relation to the taking of statutory paternity leave, such that going forward they'll be able to take it in two separate blocks of 1 week if they wish, rather than obviously at the moment they have to choose between either taking a single week or one 2 week block, albeit I appreciate that some employers do already allow that flexibility. It's also proposed that the statutory paternity leave can be taken at any time in the first year rather than just in the first 8 weeks after birth or placement or from adoption. And it's also being proposed that the notice obligation will be reduced. Currently it's 15 weeks before birth. It's being proposed that that notice obligation is going to be reduced down to 28 days. Get ready to update your policies. A quick word in relation to holiday pay. As set out on the slide, there's some proposed reforms in relation to the joy that is rolled up holiday pay, treating different types of leave in the same way, whether or not that's directive or regulation holiday, and also how to deal with the joy that is part-year workers. In relation to pay, and apologies for the plug, but obviously yesterday we had the Supreme Court decision in relation to Agnew. Sian and I could genuinely speak for the entire hour and a quarter just on holiday pay and the significance of that. Shoosmiths are going to run a dedicated holiday pay masterclass on this. We've been chomping at the bit to announce this, but we were waiting for the decision yesterday before announcing it. It's going to be on the 8th of November at 10 o'clock. It's going to be 2 hours long on nothing but holiday pay for the bargain price of £45. So if you're interested in that, if holiday pay is key to your business like it should be, or particularly for big employers or for those who've got really complicated and different types of employees engaging typical workers and things, then please do drop a note in the questions. If you want to receive an invite, no commitment, but if you want to receive an invite to that, please put your name in the questions and we'll make sure an invite is sent out to you. Lastly on this slide, in relation to TUPE, there's some ongoing consultation on a topic that is close to Sian and my heart, which is about whether or not there should be changes to where employers have to elect employee representatives. The proposal is that employers will be able to consult directly with employees where the number of transferring employees is less than 10 and where the total number of employees employed by the business is 50. That would simplify things. The question that I would ask or would be challenging here is whether or not that actually goes far enough, but it would certainly assist some smaller employers in relation to the complicated process that it is TUPE transfers. Last slide in relation to legislation and what's on the horizon. I just wanted to pick out one thing from this, and this was the consultation that's ongoing in relation to non-compete clauses, which Sian and I are watching with great interest, given that we as a team do quite a lot of work in relation to advising on restrictive covenants and injunctive action. As many of you will be aware, there is a proposal, quite a controversial proposal, one would argue, to cap non-compete clauses in employment contracts to 3 months. Non-compete clauses are, as many of you will be aware, the hardest ones to justify in any event, but for some senior positions they are absolutely necessary. My concern here is that this is potentially one of those topics where the politicians are potentially getting involved in something that they shouldn't, and you'll note that the slide confirms that the legislation will be brought in when parliamentary time allows. My suspicion is that they may never get round to this, but it would be a very interesting development if it does. So that's the end of that. Now I'm going to whiz through 4 quick cases, all on the subject of disability discrimination, and I hope that choosing 4 cases on the same topic is useful to have a little bit of a deep dive. So the first case for me is a case of McQueen that looked at a particular strand of discrimination law, namely discrimination arising from disability, often referred to as Section 15 claims. By way of quick recap, discrimination arising from disability arises where A treats B unfavourably because of something arising as a consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim, the objective justification defence. And case law has established that the something arising in consequence of B's disability is very wide. And there's also a very loose causation test in these types of discrimination claims. So they're generally considered to be a lot easier claims to succeed in than indirect discrimination claims, which are, at the end of the day, claimants tend to argue in the alternative, but they're generally considered to be easier claims to bring than indirect discrimination claims. The facts of the case are set out on the slide, but I'll run through those quickly. Mr. McQueen suffered with various conditions, including dyslexia, some symptoms of Asperger's and hearing loss, which caused him to have some difficulties with interactions in the workplace. It wasn't in any way disputed that he was disabled. He had an occupational health assessment. He was seen by a psychologist with medical evidence indicating that in situations of stress and anxiety and conflict, he could raise his voice, he could adopt mannerisms that were suggestive of being quite aggressive and adopt sort of inappropriate speech and tone. So what happened was that he had 2 incidents of inappropriate behaviour described by the tribunal as meltdowns, and as a result of those, he was disciplined for those, for performance issues. Rather unsurprisingly, from a claim perspective, having been disciplined, he claimed that he'd been discriminated by his employer because of his disability, because his disabilities caused those confrontations. Having considered all the evidence, the tribunal found that the issues either arose out of habit or did not arise as a result of his dyslexia or his Asperger's, but because he had a short temper and he resented being told what to do. He appealed to the AT and the EAT dismissed his appeal. And this is a really interesting judgment because the EAT set out guidance on the best practice for structuring decisions in relation to Section 15 claims. I haven't got time to go through that, unfortunately. It's well worth a read. It's actually quite an easy read, but it's there's some useful summaries out there in relation to this case. And if you are facing or thinking about a Section 15 claim, it's a really, really good case to look at. But crucially in this case, both the Employment Tribunal and ultimately the EAT held that disabilities played no part in his conduct. And crucially, once they determined that disabilities didn't have any effect on his conduct, the further question of whether or not the unfavourable treatment was because of his conduct simply didn't arise. So this is a really potentially useful case for employers, but I do need to flag that, as ever in cases like this, it is incredibly fact specific, and it will be for the tribunal to conclude whether the unfavourable treatment arose because of consequences of the individual's disability. And the difficulty for you and the difficulty for us as advisors is it's very difficult to predict whether or not the tribunal will accept whether or not the behaviour is something which arises as a consequence of the individual's disability or potentially disabilities, or whether or not in this case the tribunal will accept that actually it was something very separate, but potentially a useful decision. The next case for me is a case of Achi. which is actually a claim of victimisation involved, also a claim of constructive unfair dismissal. I say this with a smile on my face. We always enjoy cases against trade unions nearly as much as we enjoy cases that have been brought against other firms of solicitors. Facts of this case is that Mr. Atchie was employed by the union. He went off sick in March 2017 and he received some sick pay. In April 2017, he raised a grievance alleging that he'd been treated unfairly. He alleged that there was a bullying culture within the union and race discrimination issues that he'd raised hadn't been taken seriously. In June 2017, it was brought to the union's attention that Mr. Atchie was listed as a tutor for a training event running by another organisation, even though he was signed off as unfit for work. The union, rather unsurprisingly, ordered an investigation into the matter, with the outcome of that being that he hadn't actually participated in it and no disciplinary action was taken. After concluding its investigation into its grievance, it was not only found to be baseless, but it was found that his grievance might have been made in bad faith and that the raising of a malicious grievance was potentially a disciplinary matter. So that was then subject to a further disciplinary investigation, which was deferred whilst he remained off sick. Mr. Atchie then appealed against the grievance, and that appeal was dismissed, with the appeal officer concluding that the grievance had been malicious. He then resigned in March 2018, and coincidentally, that was it's weird this, he resigned at the same time that his entitlement to sick pay ended. He then issued proceedings against the union alleging race discrimination, victimisation and unfair constructive dismissal. The Employment Tribunal rejected his claims and he then again appealed to the Employment Tribunal. So looking at this purely from a victimisation perspective, the Employment Appeal Tribunal decided that the decision to conduct the disciplinary investigation into his motivation for raising the grievance was not victimisation. The reason for that was nothing to do with the Protected Act, i.e. the fact that he'd raised a grievance, but the union's view that the grievance appeared to be malicious and in contravention of their bullying and harassment policy, and that these factors were capable of being distinguished from the Protected Act. And there's a couple of key learning points here. The first is to ensure that if you've got a concern that an employee might seek to bring a victimisation claim, to really clearly document the reason why you might be investigating something. The decision also illustrates that it's not every case that a purported act of retaliation in the context of a Protected Act will constitute victimisation. Once the reason for the particular treatment has been identified, what the tribunal must evaluate is whether those reasons are separate from the Protected Act, or whether they're so closely connected with it that the distinction can't fairly and sensibly withdrawn. So it's not easy to draw that separation, and that's why I repeat again the fact that if you can document your thinking about what your motivation is, then that will help you to defend a potential victimisation claim in the future. Penultimate case for me is the case of Greasley, that looked at a really key element of the law in relation to harassment. A couple of the key points arising out of this case is that firstly, a person can't be harassed if they're not aware of the unwanted conduct at the time, and secondly, that it wasn't reasonable for the claimant to have felt that his dignity had been violated by conduct that he only found out during a grievance investigation into a basically his own allegations against him that he'd been a bit of a bully. So let me bring that to life a little bit by explaining the facts of this case. By way of brief background first though, let's remind ourselves of what the law says in relation to harassment. A person A harasses another B if A engages in unwanted conduct in relation to a relevant protected characteristic, which has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment, definition that I am sure that you are familiar with. In deciding whether conduct should be regarded as having the prescribed effect, the following has to be taken into account. the perception of B, and I'm going to stress these 2 points now, the other circumstances of the case, and whether or not it was reasonable for the conduct to have that effect. The key facts of this case is that the claimant only became aware of the disparaging comments that had been made against him by colleagues as part of the grievance process that had been raised against him. He filed a claim for grievance as a result of the comments that had been made aware of those, but again, it was only as part of the investigation process. And I pause at that stage and make reference to a previous authority which had confirmed that in order to assess whether or not the conduct had the prescribed effects required for the definition of harassment, it contains both subjective and objective elements. And in the first instance, the Employment Tribunal rejected the argument that any harassment could have occurred before he'd learned about these statements. And you'd think that sort of makes common sense, doesn't it? The perception of a claimant is a mandatory element of harassment. And if a claimant had not perceived any unwanted contact because he didn't have knowledge of it, they couldn't be successful in any such claim. Secondly, and this is the key point, because this often arises in relation to complex grievances like this, the Employment Tribunal held that, the Employment Appeal Tribunal held that the tribunal had been entitled to find that it was not reasonable for the unwanted conduct to have the effect of violating the claimant's dignity, given the context of the underlying investigation. So they were basically saying it was unreasonable for him to have reacted as he had. What the tribunal didn't say was that this would be the same in every case, but on the basis of this particular case, it was unreasonable for the company to say that it amounted to harassment. So it's a useful one, but again, it's still one of those cases where we have to say, with some caveat, each case depends on the facts of the case. It doesn't provide you with a get out of jail free card, so please continue to be careful. But if the comments are not too serious as part of the grievance process, then the individual will be unable to rely on it from a harassment perspective. I promised Sean that I'd be finished by 11:35, so I've got 4 minutes for my last case. The last case, which I'll do no problem, Sean, don't worry. The last case for me is the ACOM case, which is a really interesting case, and it reminds us of the fact that the duty to make reasonable adjustments applies to employers even when an individual isn't yet an employee, so as part of the recruitment process. And this case is also particularly relevant given the fact that so many of you will be changing your recruitment processes, and so many recruitment processes now are involving more and more technology. In very brief terms, in this case, the employer required job applicants to create an online job profile and to complete an online application form. Mr. Mallon asked to make an oral application on account of the fact that he suffered with dyspraxia, but then he failed to respond to the employer's repeated requests for him to explain his difficulties with the online process by email, and I stress by email. And the EAT concluded that there was only 2 explanations for that failure. Either he was being deliberately obstructive in order to engineer a disability discrimination claim because he was not a genuine applicant, or he was having difficulty with the written communications. Once it was decided that the application was genuine, the tribunal was entitled to find that despite the failure to respond to the inquiries that had been submitted by the employer ought to have known that his dyspraxia meant that he had difficulty in accessing the online form, and that an employer acting reasonably when faced with an individual with a dyspraxia diagnosis, asking for an adjustment to avoid filling in an online form, but who failed to respond to basically reasonable requests in writing, would have telephoned the applicant in order to understand their situation. And given the applicant's difficulty with written communication, his failure to explain his situation by responding to the email was reasonable. I think this is a really important case because it reminds us, of course, of the fact that you can discriminate at the pre-employment stage, and the fact that the duty to make reasonable adjustment applies, and the fact that actually it's quite a high hurdle for employers. The case illustrates the need and the importance for employers to have robust internal procedures for dealing with issues that might arise during the recruitment process, and picking up the telephone. Sometimes it's just the simple things, isn't it? It's picking up the telephone to understand disabled job applicants' needs might seem obvious, but in this case it was overlooked. And the last point to mention, and I've got 30 seconds, I'm on time, is that this case has been remitted back to tribunal to determine whether or not the application was genuine, noting that Mr. Mallon was seeking to return to work he'd actually previously worked for them. He'd been dismissed during his probationary period previously, and that he'd made 60 other claims against other employers for discrimination. So he's potentially one of those serial litigants, but there we go. Right, 11:34, Sian, I've done what I promised. Over to you. Thank you, everyone.
Thanks, Stuart. So I shall be covering with you managing termination of employment on grounds of SOSR, SOSR. It's a half-day training session, really, that we're cramming into half an hour, but hopefully I can get across the key considerations to you. So what is SOSR, SOSR? Let's start with the basics. So in order to dismiss an employee fairly, we need to have a fair reason and we need to have a fair procedure. And if we don't have both those aspects, it can give rise to an unfair dismissal claim to the individual if they have over 2 years service. And I'll go into tribunal awards in a bit more detail later. So as we know, there are 5 potentially fair reasons for dismissal: conduct, capability, redundancy, illegality, and then some other substantial reason, otherwise known as SOSR or SOSR for short. But it's this residual kind of catch-all phrase and potentially fair reason for dismissal. Unhelpfully, there's no statutory definition or guidance of what SOSR means, but our case law has established that it needs to be a substantial reason. What does substantial mean? It means more than insignificant, frivolous, or trivial. What is substantial is a subjective test, and good old lawyer phrase, it will depend on the facts and type of the case, but it genuinely will in this case. And the reason must be of a kind which can justify the dismissal. So there's no lesser sanction that's appropriate. And what the courts also look at is the employee holding that job in question. So there are many examples of what could constitute an SOSR dismissal. I've just put on the slide here some more common examples that we tend to deal with, from your refusal to accept changes to terms and conditions, end of a fixed term contract, reputational risk can come up, or loss of confidence that the employee would maintain acceptable attendance level with your short-term persistent absences. The 3 in green are what we're going to concentrate on today. So your pressure from third parties, personality clashes and irreconcilable differences, and breakdown in trust and confidence. Before we go into that, we're just going to look at the test for a fair SOSR dismissal. It's actually a 2-stage test. So the first part of that test looks at whether the SOSR is the sole or principal reason for the dismissal. So can that SOSR reason justify the dismissal? And as you saw kind of on the slide before, that SOSR reason can be quite, wide ranging. So it's not about whether it did justify, it's whether it could justify the dismissal. But the second part of the test is the harder aspect to establish, and that's where a tribunal is going to look at whether the employer has demonstrated that it's acted reasonably in all the circumstances, and that looks at the size and resource of the company as well. So deciding whether an employer has acted reasonably in treating a SOSR reason to dismiss will involve the tribunal considering whether an employer has followed a fair procedure. You'll all be familiar with the ACAS Code of Practice on disciplinary and grievance procedures, and as we know, that applies to grievances and disciplinaries. And it expressly states in the ACAS Code in the context of disciplinaries that it applies to those based on misconduct or poor performance. So arguably, it doesn't apply to SOSR dismissals unless it could be said to be disciplinary in nature. And there was one tribunal case which did find, perhaps rather surprisingly, that the OCAS code did apply, more so on the basis that it hadn't been expressly excluded. Regardless of whether the ACAS code applies or not, procedural fairness is always going to be key to any dismissal, including SOSR dismissals. And it'll always go to kind of establishing whether an employee has acted reasonably. So you can't be criticised for following the ACAS code as closely as possible as best practice. So do make sure that you're familiar with the code. Would say for SOSR dismissals, the exact procedure and considerations that you need to take into account will depend on the type of SOSR dismissal that you're looking at, which we will hopefully bring to light over the next few slides. Yeah, if I can just briefly touch upon, what it can cost if we get it wrong. Why do we want to get this right? Well, we want to avoid those tribunal claims coming in, and the obvious one that an individual will bring in these circumstances is an unfair dismissal claim if they've got over 2 years service, and they'll probably try it even if they don't, to be honest. But a unfair dismissal claim is broken up into 2 parts. You've got the basic award, which looks much like your statutory redundancy payment. And then you've got the compensatory award, which looks at an individual's future loss of earnings. So it very much depends on how long it takes them to get another job at an equivalent level and salary. But it is capped at £105,707 or 12 months pay, whichever is the lesser amount. It's important to know employees always have an obligation to mitigate their loss. We get great pleasure in reminding them that they can't just sit idle and wait the tribunal claim. They have to be actively seeking new employment. It's never just unfair dismissal claims that we tend to receive on our desks. I can't actually remember the last pure unfair dismissal claim that we had. You'll always get discrimination or whistleblowing thrown in for good measure, where you don't need any qualifying length of service and the awards are uncapped. More and more, we often see as well other employees being joined as a respondent in addition to the company to the extent they're claiming discrimination and holding those individuals liable as well. Management time, not to be underestimated. If you do have a tribunal claim, yes, we can take a lot of the pain away from you, but still we'll need to take instructions to draft that defence. There will be directions, quite often there'll be preliminary hearings, there'll be a disclosure exercise, drafting witness statements, and of course attendance at the full hearing, all can take up a lot of time. And legal fees. So each party bears their own legal costs in a tribunal setting unless the individual's acted particularly maliciously or vexatiously. And easily, an unfair dismissal and discrimination claim 3 days in tribunal can be north of 20,000 plus, VAT. So it all adds up very quickly. So there are many good reasons to get a SOSR dismissal right. So if we can just go a bit deeper into some of these types of SOSR dismissals. The first one that we've got here is pressure from third parties, which can constitute a SOSR reason to dismiss. And the third party tends to normally be a customer or supplier of an employer. We quite often see it for our cleaning clients where their employees are going to work at their customer sites. The case law on this has established that actually the reason for the third party's request is largely irrelevant, and actually establishing the truth of any allegation made against the employee by the third party is not necessary either. The important factors that a tribunal will take into consideration when looking at the fairness will be how important is that third party's continued business to the employer? So what is the value of that customer to the company? How serious or definite is the threat from the third party? Have they actually made any ultimatum or exerted any pressure that unless you do this, we're not continuing our business with you? And also what extent the employer has tried to challenge that request. an employer needs to do everything that's reasonable to try and avoid or mitigate any injustice to the employee, and challenge the decision if it can, and consider redeployment. So that's all really important to take into account. If we just look at what a fair procedure will look like in the context of pressure from third parties, investigation, always key, understand the facts. For clients that get a lot of third-party removal requests, we would definitely endorse having some kind of internal process, and many of our clients will, where you've got a third-party, removal request form to complete, and making sure that an appropriate person is appointed to investigate, that's independent and objective. Where we see things go wrong mostly is where you've not got a process and you've got the wrong person kind of looking at it, and quite often it might be the account manager, for example, or the sales lead, who has customer satisfaction at the forefront of their mind, and possibly their own personal bonus too, but they don't, the customer says jump and they say how high, without really considering anything further. So make sure that you've got the right person appointed that is independent and objective, and that can look at it properly to assess what is the value of this customer, what have they actually said to us. Do we have enough information to understand what's going on? Do we need to investigate? Have we tried to challenge that decision with the customer? And you'll find that obviously, as an employee, you're going to understand that decision and hopefully accept it more if you feel that your employer has fought for you and tried. Noting on the slide there, obviously efforts to persuade the customer otherwise is very important consideration, and let's make sure that it's documented, that we've got some paper trail to evidence to the tribunal that we did try. And quite often, again, HR will come to us and say, well, yeah, we'd asked for information on this from the business, but the business isn't prepared to go back to the customer because they're all very busy and the customer doesn't have time for this. They've told us they're unhappy with this person, they want them removed, end of. But even if they're not prepared to fill in paperwork, is there any other way that you can evidence that paper trail? And it might just simply be a case of getting somebody to write back to the customer to note what that telephone call said and what was discussed and what was challenged and what the customer's position was and as what we understood it to be. And that is absolutely going to be better than nothing. Also flagging on the slide there, mitigation. We can't say enough that dismissal has to be the last resort. You should contemplate redeployment, and obviously that's going to be dependent on the size of your business, but you should consider it as a lesser sanction. Other practical considerations for you as a employer is always, what customer base you want to attract. Obviously, if you make it very easy for the customer just to say, I don't like them, I don't want them here anymore, and not have to do much more than that, and you always act upon it, then that will become the expectation. So if you put in a process there, it makes it slightly harder and obviously helps our paper trail. But also consider the type of employer you want to be. We've been very much in a candidate-led recruitment market for some time. Obviously, that's changing slightly, but still, if we don't look after our workforce, then they're unlikely to be loyal to us, and it kind of obviously feeds out to others. So just moving on to personality clashes, breakdown in working relationships. So these irreconcilable differences between colleagues can amount to an SOSR as well. And I think these are the types of cases within the employment team that we see more and more of every day. And it's been this trend really, I think, since COVID. It was almost like employees forgot how to behave coming out of it, or lacked the social skills. And possibly, the remote working, hybrid working, employees have lost, connections with their workforce and that loyalty and respect. And I know the keyboard warriors have come out and felt that they can just write whatever they want. And again, that candidate-led recruitment market, they know that they can go into another job. So that empathy and understanding how, what they write can impact upon others had has become a bit of a problem, really. So we're seeing more and more of these types of cases. And the common theme in dealing with all of these cases is the R word. You know, have we acted reasonably in all the circumstances? Can we demonstrate this? We tend to find with these types of cases two main kind of categories, so to speak. You'll get the disruptive individual, possibly kind of the lowest skilled end with a protected characteristic or two that they'll use as their armour. They'll do what they want, say what they want, disrespectful to all, including, you know, their line managers, a law upon themselves, everybody's treading on eggshells around them. Grievances might be raised against them and they'll reciprocate with the grievance back that they're being picked on or scapegoated, and nobody wants to work with them. But whatever they do isn't quite kind of enough to amount to gross misconduct and largely unaddressed. One of my clients referred to this type of individual, which I thought was quite apt, as a growth, in that they infect everyone around them. Not how I'd like to be described, but there we go. And the other kind of common scenario that we come across in these circumstances are two employees at senior management level, board level, and they just clash. They just rub up against each other the wrong way and undermine one another. They're rude to one another, abrupt in their exchanges, and one person ultimately has to go at some point. And quite often you'll probably have a protected characteristic phone in these circumstances as well. So in order for a employer to dismiss in these circumstances, you need to evidence this substantial disruption that's happening to the business. And you need to look at the effect the individual's behaviour is having on the business. And the type of disruption that you quite typically see in these scenarios is them not wanting to work alongside one another. You might start taking annual leave at the same time the other person's scheduled to be working with you, or long-term sickness where individuals are going off for months with, you know, mental health and well-being being severely impacted, and then that of course drips through and impacts upon the others that are left within the business, affecting morale and productivity and the general operations of your business as people aren't free to communicate. And grievance after grievance will of course also take up management time, and this is all significant disruption to the business, and you need to be recording all of this. It's important to investigate any allegations and have somebody that's independent and objective looking in, understanding both sides of the story. What is, you know, it's easy to say that you should try and nip these issues in the bud at an early stage, and if you recognise these behaviours are happening, make sure that we're clear to individuals as to what's acceptable, what's not. Unfortunately, they largely go unaddressed, and then the individual will make, I know, a protected disclosure or seek to try or make an allegation of discriminatory conduct, and enough's enough, and quite often we'll see these knee-jerk reactions happening at this point that we can't stand this person here any longer. And that isn't acting reasonably. So try and avoid these knee-jerk reactions, take a deep breath, and let's look at getting the paper trail right. With the personality clashes on a one-to-one basis at a senior level, the disruption can be slightly different, but, you know, very significant still. You know, if you can't have managers operating efficiently, then that's going to be very disruptive and destabilizing to the company, and you can't move forward. As I flagged, and I'll continue to flag, you know, it always has to be that dismissal is a last resort. So you need to explore other options first. So mediation being obvious there, you do need to kind of look at whether that is an option. And quite often the business will say, no, the relationship's already broken down so much that it'll be completely futile, not happening. Well, at least show that you've considered it and document why it's not appropriate. Redeployment to another team. Oh no, just going back to the mediation point, actually, if you ask the individual concerned, quite often they'll equally say, no, relationship's broken down irretrievably, document that. They don't want to engage in the mediation as well. That's helpful actually for us. Redeployment to another team, obviously this is going to be dependent on the size of the business and what level the individual's operating at, but do consider whether that is an option, and again, if it's not, show that you actually have given consideration to it. One case of mine and Stuart's actually that we will always remember is an individual who was very hostile, raised grievance after grievance, sent threats, filed police reports against all board members and Stuart. I was ghosting it at the time, and in the police report and the description of suspect, he describes Stuart as looking like Uncle Fester, which I like sharing with everyone when I get the opportunity. So this individual, he said he was non-binary, he self-identified as an attack helicopter, as you do, and wanted to be called Blue Thunder. That aside, he'd brought 6 tribunal claims, he'd sent nearly 60 emails to numerous individuals over a weekend. You know, that's enough to give you heart palpitations, isn't it? But the company acted very sensibly and reasonably on our advice. They warned and consulted with the individual. They made it very clear, look, we don't mind you raising these grievances or bringing any claims, but the manner in which you are doing so and this scattergun approach and to the various number of individuals that he was contacting was highly unreasonable, highly inappropriate, and we spelled out exactly what he was to do going forward should he wish to raise complaints, which was a single point of contact, gave him a anticipated response time and that he wasn't kind of to chase a response sooner than that. And he basically showed that, well, he refused to listen to that reasonable instruction, and it got to a point where it was necessary to invite him to a SOSR dismissal meeting. And the history there that you could lay out for him just showed how unreasonable he was and the fact that he wasn't going to change, and what we'd done already to warn and consult with him, and the fact that that just wasn't going to change. So he was dismissed on SOSR grounds. For the employee I described as growth earlier, he was invited to a meeting for allegations of gross misconduct as well, and that's quite often sometimes good positioning if you want to go on to have a off-the-record conversation, because at least with gross misconduct, they're not going to be entitled to their notice if there is that finding. With SOSR dismissals, individuals are still entitled to their notice period. But in this particular case, he was invited, you know, to a meeting to deal with potential allegations of gross misconduct, but also to consider whether the relationship had irretrievably broken down. And he accepted that the relationship had broken down. We did with this individual, because it was a very large organisation, look at redeployment, which he has been redeployed. And he was also given a final written warning in the end, and it won't be long before he misbehaves, and you can platform off that with a fair dismissal. So just moving on, looking at breakdown, still in working relationships, just got a couple of cases to share with you here. So conduct that makes an office atmosphere so tense that it's unbearable and seriously affects the company's business can justify a SOSR dismissal. And in this particular case, Mr. E, he was a consultant surgeon. And from the very beginning of his employment, he expressed how everybody was incompetent at their jobs, and he wrote frequent letters on that subject. And 9 senior members basically signed a petition expressing their grave concern with his conduct, and an investigator was appointed to have a look, who found that the relationship had irretrievably broken down, and he was dismissed on that basis. And he brought proceedings on the basis that he felt that the dismissal was linked to him having made 75 protected disclosures. And the tribunal looked at it and said, actually, these didn't amount to protected disclosures, but even if they did, it's clear the reason that you've been dismissed was because of this irretrievable breakdown in the working relationship, and there was that finding that it had been fair. Just moving on to the next case that we have here is of Moore and Phoenix product development. This was also a helpful case. It was an EAT case, and here they found that the SOSR dismissal was fair, despite the fact that the employer had failed to give the employee the opportunity to appeal, as it concluded it would have been futile. As we know, given an individual a right to appeal is normally invariably always part of a fair procedure. But in this particular case, it found that Mr. Moore, who was this board level director in a very small company, and there were no higher levels of management, he'd conducted himself in such a way that it brought this irreparable breakdown in trust and confidence. He was destructive, he was destabilizing, he was a drag factor for the company, and unrepentant. He showed that he wasn't going to change, and therefore concluded that actually an appeal would have been futile in those circumstances. So that's helpful. So just concluding really on the breakdown in working relationships, where employees cannot work together, an employee may dismiss on SOSR grounds if it can satisfy the situation is irredeemable. And before moving to dismiss, you should always be looking at reasonable steps to try and resolve the problem. That will include looking at redeployment, changing working patterns, attempting to mediate. Not an exhaustive list there, but what other lesser sanction could we consider here? But where that conciliation has been tried and failed, then a dismissal is likely to be fair. The tribunal will look at whether an employer has acted within the range of reasonable responses. It will look at, the investigation, whether you had that genuine belief, whether you've warned and consulted, what alternatives you've looked at, and size and resource of the company, and ultimately whether you've acted within that range of reasonable responses. So just moving on to breakdown in trust and confidence, which in itself can amount to a SOSR reason, but there's just a bit of caution urged here. So employees will quite often maintain and use that label that there's just been this loss of trust and confidence. But quite often you'll find that this category overlaps with other SOSR reasons like reputational risk or personality clashes, as well as potentially other fair reasons for dismissal, especially misconduct. So whilst SOSR, loss of trust and confidence can alone be sufficient, it's rare. And be careful about just using this as a convenient label, and that's what was highlighted in the case of Leach versus Ofcom. In this particular case, it went all the way to Court of Appeal, and the employer was basically criticised for just having relied on this particular label, because in this case, Ofcom, a public body, had dismissed an employee on the basis of a disclosure from the police that the employee had been involved in criminal activity and was a risk to children. And whilst this individual didn't work directly with children, he occupied a senior role which involved child protection issues. And they were fearful basically that this would cause great damage to their reputation to continue employing him if this got out. And that was the real reason behind the dismissal, and they should have kind of brought that to the fair, brought that as a reason to the individual, but instead they just said that they'd lost trust and confidence. So just a word of warning to make sure that we are accurate there with the real reason for the SOSR dismissal. So that is a bit of a whistle top on those three most common examples that we typically deal with a lot. In terms of key takeaways from that, it's just remembering that it can be quite wide-ranging what amounts to a SOSR reason, but it must be substantial. Make sure you've always got that documentary evidence to support what you're saying, and if it's the disruption that you're trying to identify there, and what efforts that you've made to look at alternative options before resorting to dismissal. And that dismissal needs to be within the range of reasonable responses, and that will entail making sure that you have followed a fair process. So that's me. I think we've now got some time for questions.
Hi everyone. So the question facility is still open to you if you want to ask any questions via that portal while you've got us for the next 10-12 minutes. Antonia, what's landed thus far?
Yes, so I've got kind of an interesting one which sort of picks up, I think, Sian, on what you've been talking about with SOSR dismissals, and it's around a situation is when there's clearly been a breakdown in a relationship with an employee, but how do you, I suppose it's that, how do you know when you've got enough information to move to a SOSR process? And I'm kind of thinking in particular, there's reference to, you know, perhaps somebody who's raising lots of grievances, but actually there's always part of that grievance that might be upheld. So they're not completely spurious grievances, but you can see that the relationship is breaking down, that they're not happy in the working environment. I don't know whether you've got any experience of that or any tips.
Yeah, I mean, quite often it's mutual, isn't it? And it's not healthy for anybody ultimately, and we don't want to protract these things for longer than we need to. You know, from our perspective, we do want to get ourselves, you know, into a good, you know, negotiating position, and, you know, go through that tick box exercise as I've kind of flagged of showing, you know, the disruption that they're causing, that you have, you know, tried to warn and consult with the individual to the extent, you know, it is their behaviour there that's of concern, that you have explored alternatives. And, you know, if you've done all of that and you're kind of fairly well lined up to be in a position to invite them to a SOSR type meeting, yeah, I think quite often, you know, to some degree, ideally you kind of get yourself into a position where you can have a protected conversation, ideally. And it's lovely if you can get to a place where they can see, well, you know, imminently it might be the case that we are in a place that enough's enough and we can't kind of go on either party anymore. You look to have a sensible conversation to kind of make that clear enough to the individual. But I think the individual quite often is accepting, especially when you make it look like their choice in a protected conversation scenario, that look, you know, you can kind of platform off the fact that it's very clear that they're unhappy, that they don't want to be here, that you don't want anybody working in your company, you know, where they're kind of feeling all of that pressure, and see whether you can come to a mutual, you know, agreeable settlement. And sometimes it might just be their notice that they're not required to work. You know, it doesn't have to be significant, and you're going to have to pay them their notice anyway. So there are ways around it. Yeah, no, I take the point that it's quite hard to kind of understand when do you get to that final point. Managers will make it pretty clear to you, and I think, you know, within HR you do your best to try and push it back to say, look, can we do this, can we do that, explore it. But if ultimately no, this individual's kind of caused too much disruption, I just think you can kind of conclude it there.
I'd jump in there and say there's a couple of other things to be wary about. One is obviously if somebody's raising a grievance, it's a statutory right. So, you know, you can't get rid of somebody just because of the fact they've raised a grievance. Otherwise, you're going to be looking down the barrel of an automatic unfair dismissal claim. You've always got to be wary as well of potential victimisation claims if the grievances raise issues of discrimination. These cases are pretty rare. They are becoming increasingly common, and we did actually take counsel's opinion in relation to one of the cases that Sian's referred to, and he was very keen to stress that if you're going to seek to rely on this breakdown in the relationship, then you've really got to be able to prove that the breakdown in the relationship is as a consequence of the employee's behaviour. That's the real, your focus of the attention is not necessarily the fact they raised a grievance. It might be the manner in which they are doing so. You know, they're not skilled like HR professionals are about knowing what a correct process is, but if you explain to them how they need to behave as far as that process, they ignore that and they continue to bombard. You know, the what example that Sian gave was that individual who sent 60 emails over the weekend. If they ignore those requests and they continue to behave unreasonably and copy in inappropriate people, etc., then I think you can get to the point that the breakdown has arisen as a consequence of their behaviour. It's not simply the fact they've raised a grievance.
We've had a couple of questions that have come in around the same point, which is where you've got two employees who are being disruptive, do you do you pick one over the other, or how do you deal with it when they're both? And I mean, my feeling is you have to treat them consistently, unless there is evidence that suggests one is the protagonist. If it's sort of tit for tat, if you like, I think you have to treat them in the same way.
Yeah, and you know, it depends on their role, doesn't it? And quite often it's, you know, direct reporting to the manager and that relationship that's broken down. And yes, the individual might want the manager to be, you know, moved to another team, but and you'll look, you know, equally at considering, you know, if you can move either one of them. And again, if you can't move the manager because there are no other, lines to move them to, it depends on what they're doing, or there is just that one department, then that's not going to be an option. Whereas it might be more easy to, you know, relocate the other individual. But I think, you know, we need to show that we've considered it for both and tried.
Yeah, and ultimately, I guess if there is no solution, it may be that both end up being dismissed if you can't distinguish them in any way.
Absolutely. And I suppose the situation is analogous to sometimes when individuals decide to have or choose to have relationships at work, and then it goes pear-shaped. You know, those situations can be careful, or sorry, not can be careful. You have to be careful with managing those situations, particularly if you know they allow their personal relationship to encroach on the working relationship, but you've got to be wary then of not just choosing one over the other, particularly if there's, you know, one of them's like to have particular characteristics. So yeah, it's exploring. Often you get into mediation situations, don't you, about trying to resolve issues where there's a breakdown between two individuals. Yeah.
We've had another really good question actually, and I think this brings up quite an important point. So this is an employee who's off on long-term sick but is refusing to engage in the process at all, and could that potentially be SOSR? And I think this highlights a point, I think, Stuart, we were discussing earlier around you need to make sure you get the reason for dismissal right, because if you rely on the wrong reason, even if you've gone through a fair process, it can often undermine the fairness of your dismissal. And I think if it's an absence issue, that should be an absence process. I don't know if you agree with that.
I do. I think, you know, at the end of the day, failing to follow a sickness reporting procedure is by and large a conduct issue, isn't it? It's you know, we have a process that you need to follow, and if you're not following it without justified reason, then it's a conduct issue. You know, you can potentially ramp your way up through the totting up procedures relatively quickly. The only thing I'd say there is that we have dealt with a couple of cases whereby we've ended up in a little bit of a grey area between have we got enough to dismiss on the grounds of gross misconduct, or is this actually some other substantial reason? You know, can we point to the fact that the relationship has broken down? And in those situations, you know, tribunals, quite a lot of tribunals don't like you hedging your bets, but there are occasions when you can do. And so what you can do is you can invite an individual, say, to a hearing where you've got two hats. You look at it from a conduct perspective, but you also, in your invite letter, you're saying, right, well, we're inviting you to consider these allegations of misconduct, but we're also going to have a meeting to discuss our relationship. And then the finding of the hearing manager can be, well, actually, I make this decision in relation to the gross misconduct, and I make this decision in relation to some other substantial reason. And then that almost opens up the door to you having two bites of the cherry to argue in the alternative. In the event the worst happens, you end up in tribunal. Now, I'm not saying that will happen very regularly, but there are sometimes occasions when you can, as I say, put yourself in the best position to argue both and in the alternative when you get to tribunal.
Going back to your question, Antonio, it's sometimes, you know, if you kind of stayed on the ill health capability route, if they've been off for a significant amount of time, not engaging in the process, yes, you could try and address that separately, but I guess it depends on why they're not engaging in the process, if they're too sick to or whatever. But, you know, it can be quite helpful to them not engage in it, in the sense that you'll have to start making decisions in the absence of that information, but you've tried gaining it. Yeah.
Great.
Shall I pick up one last question that I've just seen that's come in? Sensitive topic. If we discover from an outside source that the employee has been charged with an offence of downloading child pornography, can we dismiss? They're in sales and go out occasionally to school IT managers. It's incredibly sensitive. These, unfortunately, we have dealt with a number of these cases. The starting point is, and this comes as a surprise to many, is that an employee's actions outside of their workplace often don't impact or shouldn't impact on the working relationship. There are some factors that can change that. One is if they've done that during work time. The second would be if, say, for example, they had been downloading those images whilst either or using computer equipment, so either using work equipment or doing so during work time. Some employers' knee-jerk reaction to that would be that this ultimately would result in a damage to reputation point. Well, it's amazing how many times actually there isn't a damage to reputation point, because these cases do get reported in the press, and it's very rare for the employer's name actually to be named. What actually often arises or gives rise to some other substantial reason issue is that word gets out within the workplace that Blogs has committed this offence or has been doing this and has maybe been arrested by the police, and then you get almost like a vigilante group within the workplace who refuse to work to the individual, and then you almost that's when you could be in a SOSR dismissal perspective. The starting point there is that you've got to follow that, Sian's mentioned it, the reasonable process. You'd have to work with the individual, potentially with the employees, and say, well, look, we don't condone this behaviour, but this is separate, it's outside of work and it doesn't impact. Now, if the individuals still rise up against and basically say, no, we're not working with this individual, then you may well be in a situation of going, well, actually, the most appropriate action is to move towards a SOSR dismissal rather than having to deal with all of the other employees. But incredibly sensitive issues. If anybody's got any of those cases, then please do get in touch. We've got, unfortunately, quite a lot of experience of advising on those, but very, very tricky. Okay, it's 12:15. We said we'd finish on time. Catherine, are you going to come back?
I'm still here, yes. James, you're still here as well. It's a long time since you've seen us, but we are still here.
Yeah, I'm still here.
Thanks everyone for sticking with us today and sending in so many questions, and lots of you have been really engaged with wanting a copy of April's recording and also invites to the holiday pay webinar that's being hosted by Shoosmiths. So I will sort out the data behind that this afternoon and liaise with the Shoosmiths team and get those invites out to you as soon as we can. Oh, there we go. Just to say, confirm again, this has all been recorded and the recording will be shared with you later today. Huge thanks to Sian, Antonia and Stuart from Shoosmiths for sharing all your expertise so generously and answering these questions. I really appreciate it. James, thank you for sharing information about Ciphr at the top. If you missed that or want more information about what we do, you can opt in using the exit survey at the end of the webinar. There's also the opportunity at that exit survey to leave some feedback about what you'd like to see from us next, which parts of today's webinars we find most useful. That really does help us plan for if we do another one, which hopefully we will next year, and then also if we do one, what we're going to cover then. So do fill that out if you can. I really appreciate it. Thanks again, everyone. Appreciate your time today. Thanks, Stuart and team and James.
No worries.
Thank you. Have a good day, everyone.
We'll see you next time. Have a good day. Bye.
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 Bye.